Passive Pockets is presented by Equity Trust. Today, we've got a battle of the PPM, a GP attorney versus an LP investor, and we will be uncovering the key clauses in the private placement memorandum that every passive investor should know. A private placement memorandum reveals all the risks, potential benefits, and strategies in your syndication investment. It's where you find out if your goals truly align with your partners. Just wait until you see what's buried in the fine print. It might just save your next deal. Hello, passive investors. Welcome to Passive Pockets, the passive real estate investing show brought to you by Equity Trust. I'm your host, Jim Pfeiffer. Today, we're going to be joined by syndication investment experts Jeremy Rauld from Rauld Investments and Mauricio Rauld from Platinum Legal. They're going to dissect the PPM from every angle. And guess what? They might not always agree. Before we get into the episode, we've got some big news. The 2025 Passive Pocket Summit is coming to Columbus, Ohio, May 2nd and 3rd. It's your chance to hang out with more than 150 fellow investors, and you'll be able to learn from experts like Jeremy Rauld, Brian Burke, Amanda Hahn, Paul Shannon, and more. You're going to make real connections with people who get it, other investors and sponsors. As a podcast listener, you get $100 off your ticket with code PODCAST. We've got awesome sessions lined up on market trends, tax strategies, and lessons learned from a tough year in passive investing. I cannot wait to meet you there. So grab your ticket at passivepockets.com/summit. That's passivepockets.com/summit. Let's jump in. Okay, I'm super excited and just a little bit nervous about this episode. We're going to have the battle of the PPM, the private placement memorandum. We have Jeremy here, we have Mauricio, and I'm super excited to just have them, argue from different perspectives. Mauricio is going to be arguing from the GP side, general partner, and Jeremy is going to be the limited partner perspective. So let's just get right into it. We'll start with you, Mauricio. What is a PPM? Why is it important? And how does it relate to the operating agreement?
Yeah, great question. So the PPM stands for Private Placement Memorandum, and it's essentially a disclosure, not essentially, it is a disclosure document whereby the GPs or the sponsors disclose all of the important or material facts and information to the LPs so that the LPs can go into the investment with eyes wide open and can make an intelligent decision whether they want to invest or not. It's important to know what that is because certain exemptions require PPMs. And in fact, it's common practice that if you're investing in a syndication, most likely you are going to see a PPM. We can debate on another show whether one's required or not, but generally speaking, you're going to see a PPM. The best analogy I like to give is it's very similar to a medical consent form. So you go into surgery, like I always tell the story, I have terrible teeth. I always go in for oral surgery and they always, before they put me under, even though they're going to just take out my wisdom teeth or whatever, they're going to give me that yellow sheet that says all the ways that my little surgery can go wrong. I can have some bleeding. I can get an infection. I could die from getting my wisdom teeth out. Like all of those risks are disclosed in the medical consent form. I sign off on it. The doctor signs off on it and boom, we do the procedure. That's essentially what a PPM is. It's just a way to disclose all the risks, all the information that is necessary for the investor to make an intelligent decision whether to invest in your deal or not.
And how does it relate to the operating agreement?
I generally consider the operating agreement as part of the PPM. Now, and everybody does it differently, but in our offering documents, what I generally do is you have the PPM, which is the main document, and then the operating agreement is the first exhibit to the PPM. So I have an operating agreement that's an exhibit to the PPM. I have a subscription agreement that's an exhibit to the PPM. I have an investor questionnaire that's an exhibit to the PPM. And then I have a pitch deck or a business plan that's an exhibit to the PPM. I call all of those the offering documents, but technically the operating agreement is an exhibit or part of the private placement memorandum.
Okay, and Jeremy, I know it is, so I want to ask, is it important? But why is it important for the LP to review the private placement memorandum and the operating agreement?
Well, I want to start off by saying, for those of you who are not familiar, Mauricio is an attorney, and he typically will work with the managers or the general partner to create these legal documents to form the entity that everyone's going to basically invest in. And the issue is that I know Mauricio for a long time. We're friends. We have dinner, but we're on the other side of the table on this, right? Because Mauricio is paid by the manager of the GP to represent the manager of the GP. And so when you're an investor, you're going to maybe review perhaps documents that Mauricio has put together with that GP, but the protections in there are almost fully with the thought of the manager of the GP, because that's who hired Mauricio to create the documents. So with that in mind, if you want to understand the rules that the managers have to follow, the rules that you as an investor have to follow, any of the rights that you have or don't have, any requirements that the manager does, like reporting all these cash call provisions, we're going to get into some of it today. The only way to understand all that is to review the documents. I know people hate reviewing legal documents. I don't like reviewing legal documents, but when you get used to it after a while, fortunately in the syndication world, the documents become a little cookie cutter in that there's a lot of overlap regardless of who's creating them, because there's a lot of common sections they have to create with some nuances, right? And so let's talk about the tooth example. That was a good one. Imagine you go to the dentist and you don't realize that there's a certain ingredient in the anesthesia that you're allergic to because you didn't read their waiver, right? And then all of a sudden you get a major reaction and maybe something really bad happens. Well, was that on the dentist for using it, or was it on you because you didn't read it and didn't inform yourself? Legally, it's on you, right? You signed off on it, you didn't read it. So it's a similar situation here. But honestly, there's a lot of money at stake when you're investing, and you have to understand the rules, because there are plenty of times where I passed on a sponsor I really wanted to invest with. This happened a couple of years ago recently, where I just didn't agree, for example, with the cash call terms, and I just couldn't get past that one thing. Everything else about the deal looked great. Everything about the sponsor looked great, the track record, everything, right? So the legal docs are absolutely important, and the work you have to do is upfront. Once you signed off, you've approved that you're investing and you're subscribing into that opportunity, and you agree to those terms. So it's a contract, and you have to understand what you're getting into. You have to do that to protect yourself.
Very well said. So let's jump into it, right? You mentioned cash call provisions. Let's start with that. What are cash call provisions, and what are the important things you're looking for? Jeremy, we'll let you lead off.
And I am going to defer to the attorney in the room here to either correct me or to add things, right? Because I'm not an attorney. But one of the big challenges as a blanket statement with these documents is that probably one of the best scenarios for the GP is that they have the most flexibility to do whatever they want, right? So imagine, like, the best case scenario if you're running a deal is that you could do whatever you want and nobody could say anything, right, within reason. And so when it comes to the cash call provisions, sometimes there are none, okay? And actually, that's more common than people would think. If I had to guess, I would say at least a quarter of the time I see none at all. Now, let me just explain to you what that means, okay? Let's say that the sponsor wakes up one day and there's a need for cash, okay, distress or value add or whatever it is, and they can do whatever they want. That means they can literally call their brother, take a loan from their brother for 100% interest rate, right? And the investors can't do anything about it. What happens when you're in a deal that's having challenges because of a floating rate loan, and the sponsor wants to bring in a pref equity group to basically go above the common equity you invested in, and you would actually choose to potentially partake in the pref equity to help protect your position, but you didn't get the choice because the sponsor could do whatever they want. And by the way, these are real things that are happening today. That's happening often now. I'm not making that up. That's not a imaginary scenario. And so I personally have what I call optimal cash call provisions that I'm most comfortable with, and they go in a certain order, and we can get into it. But the bottom line is that it's important for rules to be set. And the cash call provisions dictate if any cash is needed for a reason where it has to be raised either in equity or debt or some other hybrid, exactly the rules that the sponsor has to follow, including, for example, first right of refusal for investors, which can be important.
So, Mauricio, what's your take on that? I mean, would you prefer in every PPM just to not even address it so the operator can do whatever they want?
No, I'd rather not. I would definitely address it. I'm actually a little surprised that Jeremy, and I'm saying he's not right. I mean, we do have a cash call provision. I want to make it very clear, because I don't want any ambiguity. Okay, if my client has a need for cash, I want him to be able, him or her, to be able to follow the procedures. Say, hey, look, we're authorized to issue a cash call, and here's how it's going to work, and nobody can challenge us because it's all written down there. The first thing I would point out on the cash call provision, going back to the definition, a cash call is just a request for additional capital. Sometimes it's called a capital call, but essentially it's for some reason the project needs additional cash and there is none, right? And most of the time it's because something has not gone well. Like recently that's the case. You know, we've got all these interest rates that are resetting. And so not only do we have more loan payments to make, but some of the banks are requiring folks to escrow a certain amount of money and they don't have it. So most of the time it's because something's not going well, but it doesn't always have to be. For example, I have a lot of people who preemptively are trying to restructure their debt that in the long term is going to be in the best interest of the project. And so they're doing a cash call to restructure. They're not in any danger of losing the property. It's not an emergency, but it's a good strategic position that where they are today. So a cash call, the first thing you'd have to determine is it mandatory Meaning if the sponsor says, hey, you've got to give us more money, you're absolutely required to, or is it sort of voluntary? Most cash calls, including technically are voluntary because most LPs who invest just want to know that, hey, I'm going to put in 50 grand or 100 grand. I don't want to have to put any more in if I don't want to. However, even though they're voluntary, there are definitely some consequences that are there if you do not do the cash call. Most of it involves something called dilution, which is even though you're not obligated to provide the particular cash that the sponsors requested, if you don't, depending on the mechanism that's in there, you're going to end up owing less of the company or getting less distributions in the future because you're either going to have more people come in, so you have more members or more investors in, or you have somebody that's putting in more money than you. And so it depends on how you structure the cash calls, but I'm a big believer that I prefer clarity. There's different schools of thought out there, but I would rather be very crystal clear in the document so I can point to them and say, hey, if it's something that my client wants to do, here is how it's going to happen. Here's the outline.
Just a couple of thoughts. First of all, the optional versus mandatory cash call. I mean, if I saw a mandatory cash call provision,
you're out.
Yeah, I'd be out because, you may not have the cash at the time and then what? And often the mandatory has very onerous penalties. But I will tell you, even the optional, which sounds like more soft and more flexible. I mean, there was a deal I saw a few years ago, true deal, where there was an optional capital call, but if you did not provide the capital call within 48 business hours of receiving it, you would actually be diluted by 50% of your equity stake. So I was considering that deal. And I liked the sponsor, and the sponsor would not make changes to it, and I passed, right? But if you don't read the documents, you won't know that's in there. And then when the time comes for a capital call, if it comes, that is a huge slap in the face. And honestly, it's your fault for not reading it, right? I mean, that's the responsibilities on the LP. I want to say one other thing, just give some people some food for thought, because I've actually been in a lot of deals that have had capital calls for positive reasons. Now, I know that hasn't been the case in the market in general recently, but in better times, I just want to point out, if you're considering a retail or office opportunity, really pay a lot of attention to the capital call provisions, because a lot of those properties, especially if there's a big diversification of tenants, have people rolling off leases all the time. Right? Office leases are commonly 1 year, 3 year, 5 year, 7 year, 10 year. Those are just common. But there's a certain percentage of tenants who just don't renew. And what happens sometimes is that for whatever reason, there may not be enough reserves to actually meet the needs of tenant improvement spending that has to happen for a positive reason. Meaning you got a brand new tenant, they want to take even more space than the previous one. There has to be a build out, and they're going to ask for capital to do so. It's going to add value to the property. You're going to have increased cash flow. But in those cases, those capital call provisions better be what you consider to be fair, because they're much more likely to occur in retail and office, especially in a diversified tenant base, than in some other properties. So it really actually depends on the asset class as well in terms of how important it is, but it's important for all of them, of course.
Jeremy, are there any other no-goes that you would think of other than the mandatory capital call or, the 48 hours or you're diluted like that? Is there anything else you would really look for?
What I'll say is that my preference is, I'm just going to lay it out. Like, I prefer the capital call to go in a specific order. And so I prefer it for it to be what I call internal debt first, meaning they go to investors on the debt side, like a short-term loan or whatever it is, with a certain interest rate first. I want to make sure the interest rate is reasonable. If it's like a 30% interest rate, that would make me pause, right? Then I would go internal equity, then external debt, then external equity. So the last thing I want happening is me getting diluted from an external source that we may or may not know, right? And so I like to go in that order. I guess you could say the furthest away we get from that order, the least comfortable I am. But it is very important for me, at the very least, for this to be really laid out very clearly, including interest rate caps and some other really important points.
This is a fabulous discussion. I'm going to toss it back to Mauricio real quick, but then we do need to move on, because if we only get through one, we're going to have to do like 6 episodes here. But this is awesome. Mauricio, was what Jeremy proposed, is that reasonable and standard, or as a representative of GPs, are you trying to tighten that up?
One of the things I do want to point out, and I love Jeremy. Jeremy lives up the street from me. We're good friends. But at the end of the day, most of the times, 99% of the time, these are take it or leave it documents. Like, we're not going to draft documents and then Jeremy's going to review them. Jeremy then emails me and says, hey, I'd like you to tweak this provision. I'm going to be like, forget it, because I'd have to change it for everyone. And if people are already in the deal, I've got to go back and change it. So unless you're an investor who's really contributing significant capital, like just think if you're $1 million investor on a $3 million deal or something, and you come back and say, hey, I don't like this provision. If we don't change this, I'm out. Then potentially we'll most likely not, because we would. But with all due respect to Jeremy, if somebody's coming in, and investing 100 grand like everybody else, and they don't like a provision. Now, if it's something obvious in the document, it's an error or something we've overlooked, then obviously we'll fix it. But generally speaking, we've already discussed what the cash call provisions are. Honestly, on my end, I don't think the cash call language really is that big of a deal for our clients. So if, for example, if Jeremy was consulting with us prior to drafting the document, said, look, in order for me to be on this, here's what I like to see, I don't think you'd get too much pushback from the client. But we draft them a certain way. The client's approved a certain way. We're not going to change it once it's already out there unless it's a major investor.
And Jim, I just want to add, I know we're going to move on here, but I find the most success in trying to negotiate these changes with an LP investor is when something isn't in there at all. And then you start talking to the actual GP themselves and you say, hey, there's no capital call provisions. Oh, my attorney made the documents. That's what they thought was best. And I say, well, hey, you can go to your brother and get like 100% interest loan, and they're like, oh, I would never do that. I said, I understand that, but you can. And so we just put some rules in there. And that's the most success I have where, I wouldn't say it's omitted like Mauricio was saying, but it's reasonable ask. That sometimes can work.
Excellent. All right, let's move on to the indemnification clause. I practiced saying that for 5 minutes before we got on here. So what is it and how can it protect the general partner? Mauricio, you can lead us off on this one.
It's funny, until Jeremy brought this topic up at last year's, left field investor, he was on there and he brought this issue of indemnification. I hadn't thought twice about it. I'm going to be honest, it's pretty templated language in there, which I haven't looked at really closely in years. And I actually went over and looked at it, before in preparation for this thing. But indemnification essentially means what happens if somebody sues the company or sues the manager, really specifically. I think Jeremy's concern is more of the manager, but let's assume that the investors sue the manager. That's probably the biggest concern, right? There's the managers are not doing a very good job. The investors sue them or somebody else sues them, or maybe a regulator comes in and regulates them. And the manager basically uses company funds to pay for the attorney fees, to cover their costs during this investigation or during this lawsuit. And maybe even if there's a judgment, the judgment doesn't get paid out of the pocket of the manager or the person, but actually comes out of the company coffers, which obviously are the investors. And so generally you're going to have some indemnification provisions. And I think where Jeremy, and I'll let him articulate what his major beefs are, but what are the limits of the indemnification? Is it like unlimited, like no matter what? If something happens to the managers, the company will step in and defend them and hire an attorney for them and protect them until the bitter end? Or are there some restrictions, meaning, hey, if you intentionally did something or defrauded people, or what are the parameters where maybe that indemnification doesn't happen? I honestly reviewed the docs, and of course, not surprisingly, my language on the indemnification is extremely friendly for the GP. Again, I represent the GP. I don't want to sound blunt. I'm not looking out for Jeremy's best interest. I'm not looking out for the LP's best interest. I want to make it as easy for the GP to do what they want to do. And if there's any issues, that they're protected to the max. So I'll let Jeremy talk about what specific concerns he has. In mine, honestly, as long as my client has acted in good faith and didn't know he was doing anything wrong, he's going to get indemnified.
Yeah, and before you jump in here, Jeremy, I just want to say, Mauricio, you are looking out for the GP, but I don't want people to misconstrue. You're not setting up documents to adversely affect the LP. You're just thinking GP first. You're not trying to be unfair, clearly. So I just wanted to say that.
Indirectly, the documents are there to protect the LPs, right? I have a legal obligation. My clients have a legal obligation to disclose all of the information. But I almost think of the PPM also, it is kind of I don't want to say get out of jail free card, but it is a document that helps the client, because as long as we disclose everything and it's very clear and it's in the documents, honestly, we can do pretty much whatever we want. It just has to be disclosed. If I don't put anything in the indemnification provision, then we can argue as to whether my client should enjoy indemnification or to what extent. But if I articulate it, and mine's like a page and a half or 2 pages of the indemnification, and it's right there in the document, and you agree to it, then that's how it's going to work.
Jeremy, talk to us about this clause.
Yeah, so the good news is that almost all of the time, I do see some carve-outs in the indemnification. And so I have 2 concerns about this clause to Mauricio's point. Number 1 is exactly what the carve-outs are and what the language is. And number 2 is, do those carve-outs only trigger or actually become effective if they're actually found to be true by a judge? Let's talk about the actual verbiage first. There's 3 words I typically try to get in there or like to see, right? It would be fraud, willful misconduct, and the third one is the hardest one, which is mismanagement. And I'll explain those. So I'm not an attorney. I'm not going to explain what all those mean. But essentially, I think fraud is kind of self-explanatory without getting into the legalese. Willful misconduct, and I'll let maybe Mauricio give a better definition. Well, I don't want to give a legal definition. Why don't you give a quick one on that?
Yeah, that you knew what the standard of care was, and you sort of intentionally or were aware, maybe that's a better word, you were aware that you were falling behind the standard of care and you went ahead and did it anyway.
Yeah, that's the willful. So, and then mismanagement. So mismanagement is the most ambiguous, right? And so that could be debated, right? And that's where like someone like Mauricio probably doesn't like it. It's the one I sometimes see omitted. Fraud and willful misconduct is a little bit more common. And I think it's because if you're trying to protect a GP, then that's a pretty high bar for them to kind of miss. And they probably are doing something wrong. But mismanagement, if it's in there, that's kind of a, not an ace in the hole for LPs, but it's almost like a jack or queen in the hole for LPs. So that's the one that I try to find in there. Now, again, my approach is that if none of that's in there, that's a huge problem for me and frankly, potentially a showstopper. If mismanagement's missing, I might ask if they can put it in. Again, like Mauricio says, I don't have much leverage, but it doesn't hurt to ask, right? But you want to look for those words, in my opinion. I think they're key because I just can't stress enough. Can you imagine a scenario where there isn't any of those terms and fraud is actually found to be true even by a judge, and then literally the LLC you invested in is paying for the full defense and the cost of whatever the judgment was for the GP when they were fraudulent from the money you put in, the money was supposed to come in your pocket from cash flow. That could actually happen, of course, right? So it's important to take a look at those clauses. Let me get to the second piece that can be also very difficult, is notwithstanding all three of those words being in there, imagine a difference between mismanagement trying to be proven if you're suing a manager versus the onus is on a judge potentially. Like imagine all the time it takes and the risk it takes to actually investors invest money to sue the manager, have to go through an entire court case and appear in front of a judge who can be appealed and appealed and appealed and found to be guilty of fraud, right? Or guilty of mismanagement. There's verbiage sometimes in those indemnifications where a judge's ruling is required, but sometimes it isn't. And of course, if a judge's ruling is not required, it's much more friendly for investors because you have to take a step back and ask yourself, do you want to spend potentially years litigating just to get that ruling so that the money that was spent protecting the GP the whole time is then supposed to be clawed back, which is a whole other problem, right? So, it's important to really take a look at that particular clause. That's why I look at it so carefully, Mauricio.
One thing I'd like to also point out, even though I did say earlier, which is true, that it's a take it or leave it document, meaning if you don't like it, you either invest or not. However, if you do raise your concerns and, my client ends up losing an investor or two because of a certain provision in there that, hey, it didn't have the word willful in there and they end up losing one or two investors because of it, be assured that the next time around, that's going to come up again and the next set of documents are going to, that's going to be discussed and we can then have that discussion whether we want to add the willful or not. It's not going to happen in the specific one you're looking at, but it could potentially affect future PPMs that the client, they may not even be aware of it. I'll be honest with you. Like I said, I was reading the documents. These documents have been around. I've been practicing for 25 years. Now, again, 99% of people don't even read the PPM. That may be a reason why. And if Jeremy had invested in one of these, he probably would have pointed it out. But mine literally says, as long as they acted in good faith. Now, good faith implies there's no fraud, there's no intentional misconduct, because obviously that would not be in good faith. But as you can see, as long as my client's acting in good faith, there's going to be a very strong argument that indemnification is going to be allowed, and they're going to be able to, basically use company funds in order to pay for the defense for whatever legal fees are to deal with that.
Excellent. All right. So we're going to move to the next one, which is preferred return language and waterfall structure. Mauricio, I guess I'll lead off with you. What's a pref? How does it work? And are there potential misalignments between the GP and LP that we should be looking out for here?
Yeah, I think on this one, Jeremy and I may be a little bit more aligned. So a preferred return, I'll tell you what it's not. A preferred return is not a guaranteed return. That's what sometimes investors get that confused. So if you see something like a percentage, like, hey, this deal has an 8% preferred return, that does not mean that you are going to get 8% return that year. All it means is that you are going to get 100% of whatever's available to be distributed until you get to that 8%, right? So if that year, especially at the beginning, there was only 6% to divvy out, then you're going to get 6%. Now, what's critical to look at in the documentation is what happens if you're short, right? So if you have an 8% pref and in year one, you only got 4%, What happens to that remaining 4%? Does it just disappear and you're like, well, SOL, we only got 4% this year, even though we said you had an 8? Or does it roll over to the following year, meaning the following year, I have to not only give you the 8% that I promised on the pref, but I also owe you 4% from the year before, and that can kind of keep going year after year. Sometimes I can get caught up at the back end of the deal, but that's critical language for you to look at. Usually you see language, I would say the common practice is to roll those over, but that's not a guaranteed thing, and you've got to look at the documentation. In our documents, I really like to spend a lot of time on the definition section. So in our docs, you'll see a definition of what a preferred return is, and that's where all of that's going to be laid out. And then the last thing, and I'll turn it over to Jeremy, the last thing that's really, really important for you to look at is what is the preferred return based on? Is it based on your capital contribution, or is it based on your unrecovered capital contribution? Meaning sometimes the cash flow that's coming to you, instead of being a profit, it's just reducing your initial capital. So for example, I invest $100,000 and in year one, you gave me $10,000 back, right? Well, now my unrecovered capital went down from 100,000 to 90,000. The question is my preferred return 8% based on the 90,000, or is it based on the original 100,000? Because as you can see, if year two, I've got another 10,000, now I'm down to 80, down to 70, and so that preferred return can go down a lot. So look for those terms, either unrecovered capital, or they have different terms. We use unrecovered capital. But I think those are the two big, in my mind, the two big ones. Does the deficiency roll over, or what happens to deficiency? And then what is the pref based on? What's the number that you're going to use to calculate?
And Jeremy, before you jump in here, I just want to say that there are several times when I've tried to have that conversation with the operator and they didn't even understand what their document said, where they said, no, it's based on the initial contributed capital. And I read the documents and said, well, it says differently in your documents. And they said, well, no, but that's not how we do it. So you really have to make sure that you're checking all three things or every different situation. So what I do is I ask the operator what they think it is. And then I make sure that the offering document, meaning the pitch deck, and the operating agreement and the PPM all say the same thing, and that the operator agrees with how I interpret what it says. So I just wanted to add that color in there, but Jeremy, go ahead.
Honestly, I find it's more common than anyone would think that you have a conversation and either they say, oh yeah, but we do it this way, or oh, I didn't even know that was in there. That happens a lot too, right? Because I don't necessarily take into base case that the sponsors read every single word of their documents. I hate to say it, but nobody likes reading legal documents, no offense to the attorneys, you know?
Even the attorneys don't like reviewing the documents again. That's why you see so many typos in them.
Oh, that's funny. So let's talk about the preferred return. So one thing that Mauricio touched upon, which I think was really critical, is that if there's an arrears, meaning they don't hit the full preferred return and it doesn't roll over and then is caught up in the future, that to me is an absolute showstopper. I won't move forward. And the reason is because one of the ways I look at a preferred return is that it's downside protection for an investor. If a sponsor isn't performing to pro forma, they're at least going to get some type of penalty, hopefully at the worst case on the back end, if it's not caught up before then, before they actually get their profit split. If that doesn't roll over and imagine one year you get 3%, but there's no penalty for the sponsor and it doesn't roll over, and the next year they can pay you 8%, but they're never catching up what you missed. That to me is not really holding the sponsor fully accountable in terms of what you're expected to get. So that's number one. That's really important. Number two is that I have a very strong preference for the preferred return being on the current capital, but I call it the current capital balance. But to me, what's really critical is to understand in some documents, let's say that you get that 8% preferred return, right? In many cases, or most cases, I don't see that reducing the capital balance outstanding. It's just a preferred return. But over the pref, let's say there's 10% total distributed, and to make it really easy, let's say it's a 50-50 split, so there's 1 and 1 that's being sent to the LP and the operator. That 1% extra that you get, is that considered a return of capital? Or is that just considered just distribution of cash flow? Also, with different ways it can be handled is that sometimes that additional 2% is paid back to the investor, but at the expense that their capital balance is reduced because the sponsor's goal is to get the capital balance down as quickly as possible so they end up getting their split as quickly as possible. So there's actually multiple ways this can be done. It can be really, sliced and diced differently. And just make sure you read this because people are often surprised at how that's handled because they didn't read the documents. They didn't realize that it was done a certain way. Another very important provision, I'm in a deal right now where I got frustrated by this because I missed it when I read it, is that I've been in a deal that basically had a lot of properties. It's a big fund, and they did a bunch of refis. And they were arrears on the preferred return. The refis, which was I think it was based on a 70-30 split for investors. Usually, if you have a capital event, a refinance or sale, it's stipulated what order the payments have to go out in. Okay. In this particular case, which was very unusual and too favorable for the sponsor, they didn't actually have to fulfill making up the preferred return. And in fact, what they chose to do is take their 30% split, even though they were way behind on the pref. Okay. Because they could. Now, here's what's critical, and Mauricio, you'll attest to this. Just because someone can, it doesn't mean they will. Right. So they always say, oh, yeah, that's not how we work. That's not how we work. And the truth is the proof's in the pudding when it actually, occurs and we see what happens. But because you're in the deal that allowed them to, and they had that flexibility and they chose to, there's nothing you can do about it. Whereas what you could have done about it is passed on the deal or maybe pointed it out and maybe gotten it changed. I mean, I know that's a remote chance, but the point is that you can't be disappointed by that if you didn't read the deal closely enough and not see it, and then it occurs, because literally the sponsor's following the rules.
And I will say that I can guarantee you that whoever you're dealing with is not one of our clients, because that's something that I'm very, very particular about. And I do believe that any refinance of a sort of a cash out refinance is the equivalent of pulling equity out of it. So it's almost as if you sold it. And so what I like about my documents is that not only do we spell it out really clearly, that's what we're known for, but it's literally, I enumerate it 1, 2, 3, 4, 5. So number one always is 100% of that cash flow from the refinance is going to go to the investors until their preferred return is brought back to even. Then after that, 100% of what's left over is going to go back to the investors until they're made whole. All of their initial capital is brought back, or maybe unrecovered capital. And then only after that, after the investors have all their pref, all their original capital back, then we start looking at splitting 50-50, 70-20, 70-30, 80-20 or whatever. And it's literally boom, 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 one after another.
And I consider that to be the most fair, and I actually consider it to be by far the most common. So what I just mentioned before, which is a real life scenario, is actually an exception, thankfully. But that's why it's important to read the docs. One more thing I really should have said at the beginning. A lot of this is very subjective, right? Just because I like to see a cash call done in a certain way doesn't mean the next person's going to. It's very subjective. So the important thing here is that you as an LP are reading the docs and okay with the terms. That's really all that matters.
That's a great point. You have to know what you're getting into and be okay with it. And so I just want to ask a follow-up question, Mauricio. In that, the way that Jeremy explained that one deal that he's a little bit disappointed in because they can do it differently than the optimal waterfall that you just explained. You said something that they do it just because they can, but are they allowed to do it the way that you spelled out, even though their documents say otherwise? Meaning, if the documents say one thing, do they have to do that? Or can they do it in a way that is better for the LPs, but goes against what the actual agreement says? Do you understand what I'm trying to ask?
Yes, I know where you're going with that. I mean, generally we do it how we spell it out, but if it's beneficial to the LPs, usually nobody's going to complain. I mean, there's no issues really arise. So if my client came back, like, I know we're supposed to take 80% of the profits on this one, but I only want to take 70. I'm not going to advise, yes, you're not following the distribution in the documents, but I'm not going to push back on that, right?
Moving on, we want to go to voting requirements, which is, manager replacement, selling assets. Jeremy, we'll let you go first on this one. What are your thoughts on this and what are you looking for?
Generally speaking, in voting requirements, I look out for two things. One is there a vote for a major event? Because very often there isn't. And for you as an investor, do you require one or not, right? So do you want to be part of a vote, even though you may be a small percentage, you may be a small piece of a big deal with a lot of investors pulled together? Do you only want to be in deals where you have a say whether something should be sold or not, right? Or some other material event? And the other, which actually I'm much more concerned about in general, is if there's a co-invest by the managers and or any of their affiliates, how is that handled in the voting? That to me is the sneaky one that could put, and I've actually seen it before, if you read the docs carefully, there are times where, because a manager is never going to vote themselves out, by definition, with like a supermajority vote, and they have a certain percentage of the vote because they co-invest, and that co-investment is considered on the LP side in terms of voting, there's actually no way to ever vote the managers out. Legally, that could be true. And so, Mauricio can probably expand on it a little bit, but I will go and try and change. It all depends on the verbiage, and it might go from, let's say, supermajority of 90% plus, and they have 15, 20%. Maybe I'll bring it down to 2/3, right? So that we don't have that challenge. Because honestly, that's the one most common thing that I point out to a GP, and the first thing they say is, "Oh, I didn't realize it was like that." They kind of acknowledge that doesn't sound very fair. Like nobody can ever vote me out. And so we'll get into like, okay, well, their interest is to have it as high in, vote as possible to make it as most difficult to be voted out. So it becomes a bit of a negotiation. That to me is one of the more common ones you potentially can negotiate because it's more reasonable. But I'll let Mauricio throw in his thoughts here.
I can't wait to hear how he sneaks something in there. So tell us all your super secrets.
I'm on both sides of this one because I think a lot of operating agreements, especially in a GPLP, they'll just say, look, LPs have zero voting rights. Like you're a limited partner, you have zero. I come back, I'm like, well, there's certain things like, like the manager can't just like take a loan out of like if you're going to have a manager loan, that probably needs to have a vote of the members. And, if you want to change the pref, right, then one of the preferred allocations, and instead of going like, well, I know I've been giving you an 8% pref, but now we're going to vote and we're going to change that to a 4% pref. Like those kind of things, I'm like, let's have the investors almost have veto rights on that because that really does that. I do exactly what you mentioned, Jeremy. So for example, let's say I will say that the voting requires sometimes it's a supermajority, like a 2/3. Or sometimes I even have 3/4. I'll discuss that with the client. But just imagine this is a more of an extreme example. But let's imagine that in order to fire the manager or get anything done, you need a 75% vote in order to approve that of the company as a whole. That's how you got to be very, very careful about how it's worded. Is it a company as a whole or is it 75% of the class of the particular class? I will say as a whole, because even if it's an 80-20 split, if you got 100% a unanimous vote, you would be at 80, right? So here we're at 75. So you basically have to get like a 95, 90%. And to your point, Jeremy, I don't do it for this reason, but I always recommend clients when they're putting actual dollars into the deal that they put it in with the investors, Class A. Not because I don't do it because of the voting part, although that does have obviously a major effect. I do it because, hey, if you're putting cash in the deal and there's a preferred return, I believe my client's cash should have that preferred return just like any other LP. They're basically an LP and a GP. But to your point, that would also give them voting rights. And so now, can you even mathematically get to 75% if your vote counts for more than 5%, then mathematically you might never be able to get there.
So that's a real scenario that I've seen before. And I also want to point out that even if, let's say the scenario that they don't have, but they have the 80-20, but they don't have any additional equity, getting 95% of investors to vote. By the way, if there's 150 investors, what happens when 10 people have changed their email, can't be reached, aren't paying any attention, and there's a very strict deadline, right? So there are challenges potentially. This is subjective, so you could still be comfortable with that, but you have to understand the scenario and make sure you are comfortable with it. And I just want to say, Mauricio, one important thing that I try to do is that let's say that there is that conflict where the manager can never be voted out. What I'll typically try to do is exactly what you said. I'll try to negotiate it so that the vote is for the class of members that is just the actual outside LP investors, not the affiliates or the actual manager themselves.
And then, by the way, in my documents, just as an additional barrier, you cannot vote the manager off the island, as I like to say, for any reason. Like just because you don't like them or you don't think they're doing a good job or you just don't agree with their positions. No. It has to be for cause. And cause is defined very specifically. And that's where I have a lot of the willful, fraudulent, commingling, all that kind of language in there. But generally speaking, if you're just like, hey, this property isn't doing well, I just don't like the way the manager is handling it, I don't think he's doing a very good job, let's remove him. That's not cause.
That's actually what makes all of this really important, because this is one of the parts of the operating agreement that I find that the attorneys lean kind of more extreme towards protecting the GP almost at all costs, right? And they're trying to kind of achieve both fairness, but like they're also trying to achieve, the investors shouldn't just be upset because they spent $20,000 on this and they all get together and they vote them out. And now like all this work that the GP has done, I kind of understand that. But at the same time, again, imagine if a judge has to prove that there was willful misconduct when you want to vote a manager out who's been obviously, to any reasonable person, completely mismanaging the property. In that more extreme scenario, you'll spend years and a lot of attorney dollars just trying to get the manager out where everything's being mismanaged. And so you have to make sure you're comfortable with that possibility, right? So again, it's all about reading the docs and making sure you're comfortable with the scenario.
In practice, how does this work? Because when I invest in as a limited partner, I am now part of this LLC. I'm a part owner of this company. I don't know who the other members are. I don't get a list of email addresses and contact names of the other people that are investors. So a couple questions here. Mauricio, am I entitled to that? And if not, if I want to do a vote because I think the manager is, mismanaging or whatever, how do I get that started? Like, how do I find out who to even get voting? That's the question I have.
I think I might be in the minority here, but this is where I actually do side a little bit more with the LPs. And it's not because I want to, but I just think from a legal principle in the cap table, right? So you have a cap table, it's Exhibit A, that has to have the investor's name. And I prefer the address. I don't want to make it easy. So I don't want to you give emails out, they'll put together a Facebook group and suddenly it's like, it's all kinds of stuff will go on. But a mailing address and the amount that they invested or their percentage interest, because that's the exact point. Sometimes clients want to say, well, I don't want to provide that information, or they come up with like, well, the investors are private. They don't want their information revealed. And my pushback there is exactly this. There are very limited circumstances where the LPs get to vote, but in those scenarios, the operating agreement there's a procedure of how to call for a vote. And if you don't have anybody else's information or contact information to give proper legal notice, how are they going to execute their rights under the operating agreement? So my documents have an Exhibit A. They have all the investors listed in there. Now, if the investor's got a privacy concern, which I would, so I'm totally on board of that, that's up to the investor to go set this up in Wyoming or have some kind of a private company out there that nobody can know it's them. And that's on them. It's not on me to protect them from a privacy standpoint. But yes, if you look at my operating agreements on Exhibit A, you should have a cap table, name, last known address, and percentages. And some states require that. Like that's some of the states, Wyoming comes to mind and Nevada comes to mind, where that's one of the rights that members have. Like they have the right to request certain records and information. And so tax returns, financials, and that's one of them is the co-LPs are really the members of the LLC.
Yeah, I just want to add to that. So I was going to say, because I've been in scenarios, I learned the hard way that it's state by state, because this is not relevant for real estate syndication, but I invested in a startup and convertible debt. And I read it, but I missed this one really weird clause where there were a whole bunch of convertible debt holders from the same round. And as it turned out, you didn't get your own choice to convert your own debt at any time. It actually had to be a unanimous vote of everybody to convert at the same time. And I actually got unanimous voted out to convert when I wouldn't have, which I've never heard of or seen before. And it was very unusual and actually really detrimental to me, in my opinion, at that time. And when I requested the cap table, they actually wouldn't give it to me. And as I found out in the end, because it was debt as opposed to equity in California, I didn't have a right to it. Hopefully I understood that correctly. But had it been equity, I may have had a right to it. But then there's another problem. There's a vote that's happening within 5 days. And if the person refuses to give it to you within that 5 days, but gives it to you 2 weeks later or a month later before they get sued for it, then that didn't help either, right? But it is very unusual that I see the proper cap, the full cap table with the final documents, that the countersigned documents included. That's not common.
Yeah, I don't think I've seen that. I need to look more carefully. Obviously, PPM is not my strength, but that's something I need to start looking at.
I just don't know how you get around that vote. The operating agreement gives the members there's the requirement that they go through a process to get a vote down. And if they can't get a hold of everybody, I don't. So the only solution I've really come up with, if somebody really wanted to do that, is to have some kind of an escrow account or somebody who does have the list. So the members don't see it, but at least they can give notice to this escrow officer who has the list, who can then in turn give the proper notice to all the other. Otherwise, there's no way for them to do their obligations under the operating agreement.
I was a part of one deal where we voted out the manager, and I have no idea how the person who got it started got everyone's information, but somehow they did, and it must have been an inside employee who was left and wanted to be the new manager. I think is probably what happened, but that was just a disaster. So very interesting. And again, it just says you got to look at things before you invest and make sure you understand the PPM. And I do want to move on. We got the one last one. We're running up on time here, but reporting requirements. You both are giggling, so I can't wait to hear what this one is. Jeremy, we'll start with you. Reporting requirements. What are they and what's the deal?
I'll tell everybody what's going through Mauricio's mind. He's laughing because he just wants to keep them from time to time. The manager may provide reporting, and that's literally the beginning and end of the paragraph. No offense to Mauricio, but just general attorney statement. So he's laughing because it's really rare to see very specific verbiage surrounding this. And if you're the kind of person who A, expects a report within 60 days or 45 days at the close of the quarter and expects it to include at least a summary of the quarter, a summary of the operations, some type of very high level income statement, whatever you want to see, it's very rare for documents to require it. Meaning that if it isn't sent to you, despite what may have been told to you, or maybe even samples you've seen in the past, that the sponsor's not in breach of the operating agreement. And so it's very difficult to negotiate very specific items to be included because they like to keep the most flexibility possible. So what I typically will tell people is, look, there's two challenges, right? There's A, is there a requirement to send the report? And does it have to be on a specific schedule? Does it have to be within 60 days of the close of each quarter? Which to me seems very reasonable, but is almost never there. right?
They're definitely there in my docs.
Okay, well, that's unusual. So that's number one. Are you comfortable if it's not in there? Because often it's not in there. And number two is, are you comfortable without any specific requirements being in those reports, right? And actually, even higher level, are you comfortable with the reports you're going to get that this sponsor just tends to generate? Some people want a 10-page report. Some people are okay with a one-page report. But what I find very commonly is that the key is to ask for a sample recent quarterly report. They can redact it if they want to. Just say, I want a typical sample report, a template to use so I know what to expect. Right? Because I cannot tell you the amount of times I've talked to other LPs and they get their first couple of reports and they're like, well, where's the details? And I said, well, they don't include details with this sponsor, like X, Y, and Z. And honestly, had they just asked for a sample report, they may have not moved forward, but I consider it their fault for not checking, because you should already understand what you're going to be getting in advance, right? Otherwise, you're going in blindly, like as if you're not reading the documents.
There's zero details on what the report looks like. So I'm with you on that. I mean, ours definitely require it and it's within 30 days of the end of the quarter. But what that looks like, is it a 1 page or 100 page? Are they spending a lot of time on it? I don't even know. Like, I don't have any issues with your request. I mean, I think that's something that makes a ton of sense, that say, hey, it'll give me the last 2 or 3 reports, maybe not even of a current deal, but one that already closed, or even better, like it's closed cycle, show me one that you did. And yes, you can redact all the information, but that'll give me some idea of what kind of reports. Because you're right, I've actually gotten some reports where it's like a balance, like it's just like a balance, like it just makes like, this isn't telling me anything. And I'm like, so that's, I think that's good. That's a best practice that I would implement, to get that in the legal docs of what exactly is going to be provided, other than a quarterly report. Like I said, mine will just say the company shall provide a report within 30 days at the end of the quarter.
I'm going to make a suggestion to Mauricio after 25 years of practice, or how many years it's been, to make a change. And like, as if I have any experience as an attorney, but I believe in the principle of fairness in general. And so if I see a deal that isn't fair for sponsors, whether it's too high a split, there's not enough fees, I'm going to be concerned that they're not going to be motivated to continue. So in this case, similarly, I would tell you to switch that requirement to 60 days, even if they want to send it with their 30 days, because I don't actually find 30 days to be reasonable for some people, depending on how busy they are and their level of staff. Very commonly, I get stuff in 45 days to 60 days. And if it's in there and they breach it because they sent it on the 33rd day, I would tell you to switch it to like 60 days, just to give them flexibility.
Well, the good thing is I'm, after 25 years, retired or semi-retired, so I don't draft these things anymore. I focus on my coaching stuff. But yeah, I'll pass that along to the attorneys I still coordinate with.
Excellent. Well, guys, this has been fantastic. I have one more question for each of you. And, Mauricio, I know you represent, or used to represent, the GPs, but this podcast is focused on limited partners. So we're going to ask for advice to give LPs. So what is one thing, not necessarily an item in the PPM, but when an LP is trying to navigate, figuring out how to look at the PPM and do I want to invest in this deal because of the PPM, what is something or a strategy that LPs should use for just making sure that they're all buttoned up on the PPM? So Jeremy, I'll start with you. Do you have any recommendations for navigating the PPM?
I would say that the PPM I consider to be high level. The PPM includes risk disclosures, and they're very generic, and they're supposed to be as wide cast as possible to protect the GP. But, it doesn't hurt to read them, because sometimes there's stuff you're not going to think about, right? You won't realize that there is a risk, and it's important for you to know the risks, right? And that's why they're in there. But the other piece that I find very important at PPM is very often there's a fee structure disclosure, and even a very specific listing of the various fees. That is often the easiest way, if it's in there, for an investor to get in one easy, quick place. What are all the fees? Just, plain and clear, and here they are in one little place, as opposed to trying to find them in different parts of an overview, or in different parts of an operating agreement, et cetera. So some people may dismiss the PPM and not being as important as the operating agreement, and in some ways it isn't, in that it's not, specifying the actual legal rules that we're all signing off on. But in the same way, the PPM can still be quite handy and important to review, and I would definitely tell you to read both carefully.
Great advice. Mauricio, you want to close us out?
Yeah, I'll give you 3 real quick ones. Number one, if there isn't a PPM, figure out whether one's required. There's a lot of times people don't provide PPMs and they come up with some cacamania reason why, and it's not true. So if a PPM is required and they're not giving you one, that's a red flag. I would probably walk away. Number 2, don't be afraid to hire an attorney to help you look at the docs. I used to do this when I was younger. They're still out there that for like $1,000 will actually spend some time with you so they understand what your understanding of the deal is. Then they'll review the docs, and then they'll get on a call with you and say, well, this is not what the docs say, or here are some red flags. And so getting some consultation there. And the last one I would say, which you actually brought up before the show, make sure that the PPM, operating room, and pitch deck, they all match. right? It's not uncommon, unfortunately, that you might even see a certain preferred return in the PPM, but that's different from what's in the operating agreement. At the end of the day, the operating agreement is actually the document that actually governs everything. So whatever's in the operating agreement really governs, but just make sure everything matches, because you'll be surprised how many times they don't.
And Jim, could I just add something to the hiring of the attorney? I think that is a good idea for someone's new, but I want to point out when I first started, it was like 23 years ago, my instinct was to go hire a real estate attorney, like a real estate attorney or real estate transactional attorney. And I spent the money and they started telling me, don't do this deal because of like 20 reasons, right? Lack of control, because they just weren't familiar with the docs. They didn't really understand the syndication world. And that was the wrong person to hire. The right person to hire is a securities attorney who focuses maybe even on real estate specifically, who creates these types of docs like Mauricio, who then can give you a little bit more objective feedback on like, is this balanced? Is it fair? Because in the end of the day, you're giving up control. I tell people you're giving up control for diversification in this world and also for being passive versus active. And so you can't expect it to be perfect for you as an LP. The GP has to be able to do the day-to-day operations and do certain things. As long as it's a fair and balanced agreement and you're not missing anything, you read it all carefully, it can make a lot of sense.
Excellent. Well, thank you guys so much. I don't think there's two other people that could make an hour-long podcast about the private placement memorandum so interesting and engaging. So thank you so much. This was fantastic, and we will definitely have you on again, but we really appreciate your time. Mauricio and Jeremy, thank you.
Thanks for having us.
Thanks.
That's it for this episode of Passive Pockets, brought to you by Equity Trust. A huge thank you to Jeremy Rauld and Mauricio Rauld for walking us through the key clauses in the private placement memorandum that every passive investor should know. If you enjoyed this episode, don't forget to like, subscribe, and share your thoughts or questions in the comments. For more resources on passive investing, visit our website, passivepockets.com, and join our community with a 7-day free trial. Thanks for tuning in, and as always, happy investing.